The Insolvency and Bankruptcy Code Amendment Ordinance has been promulgated on 5th June 2020. Let's discuss. Consider hitting the subscribe button and press the bell icon for more videos on law, language and politics. Hello friends. The much awaited Insolvency and Bankruptcy Code Ordinance has finally been promulgated on 5th of June 2020. Let's take a look at some of the changes that have taken place in the law in the last 4 months in the Insolvency Code. The first is the increase in the threshold limit. The threshold limit for filing an application or petition under sections 7, 9 and 10 has been increased from 1 lakh to 1 crore. This has been done primarily to safeguard the MSME sector. MSME sector contributes around 34% to our GDP and also employs around 12 crore Indians. So the government thought fit that only if there is a default of more than 1 crore should a creditor or the company be allowed to file a petition under section 7, 9 of 10 of the Insolvency Code. The second important development is the introduction of Insolvency and Bankruptcy Ordinance. There are two major changes brought about by this ordinance. The first is insertion of section 10A. Section 10A is in line with the talk that was going on for such a long time regarding suspension of Insolvency Code. But please understand that the entire insolvency filing of new petition is not suspended. The entire IBC code is not suspended. So let's take a look at the nature and extent of the protection granted by the government under section 10A. 10A provides a protection period. So the protection period is between 25th March till 24th September. This is the first leg of protection which is granted, which is for a period of 6 months. During this time, if any default is committed by a company, then no action can be taken against them under section 7, 9, 10 of the Insolvency Code. If for instance, if there is a default in the bank loan, or if there are invoices which have been raised in April or May 2020 and the company has not been able to pay them, this is a default which is during the protection period starting from 25th March 2020 till 24th September. During this period, if this default has been committed, then the company is protected from an action under the Insolvency Code. Now you may ask, for how long is this protection available to the company? For instance, if there is a default, say to payment of an invoice in April. So is it the case that I cannot file a petition under insolvency for a period of 6 months and thereafter I am eligible to file a petition under section 9? For that, one has to look at the proviso to section 10A. And according to me, if there is a default in this period of 6 months or further period as the government may extend up to 1 year, then during this protection period, if there is a default, you can never file an insolvency petition. So let's take a look at the specific words in the proviso, because there might be people who have a contrary view. So the proviso reads as under: provided that no application shall ever be filed for initiation of corporate insolvency resolution process of a corporate debtor for the said default occurring during the said period. I read again: no application shall ever be filed for initiation of CIRP process. So that's why, in my interpretation, if there is a default during this period, the creditor will have to look for other options. So they, for instance, if there is a default and invoice has not been honored during this protection period, according to me, you cannot file an insolvency petition during the 6 months period and even thereafter for such a default. This is about section 10A. There is one more aspect of section 10A. Because people may ask that what if the default is of 24th of March or some period prior to 25th March 2020. In that case, can we initiate an insolvency petition? Say, can we file it today, or do we have to wait till the expiry of this protection period? The answer is no, you do not have to wait. if there is a default which has been committed by the company prior to this protection period, you can initiate the insolvency petition at any time, provided it is within limitation. This is with respect to section 10A. So if I may reiterate, the protection period is initially for 6 months. This period can be extended till 1 year. This period starts from 25th of March. You cannot file any insolvency petition under section 7, 9, 10 due for any defaults which have been committed during this protection period. For defaults which have been committed prior to 25th of March 2020, you are entitled to file an insolvency petition at any time. Even during this protection period, you can file the insolvency petition. This is regarding 10A. Now let's look at the second amendment which has been introduced by the Insolvency Ordinance. This is an amendment to section 66. Section 66 of the Insolvency Code deals with fraudulent trading and wrongful trading. For instance, somebody is trading in goods and services for the purpose of defrauding the creditors. Or if a person is involved in wrongful trading, for instance, he knows that there is a possibility that the company will not be able to pay debts. Despite that, recklessly he is continuing the business of the company without bothering whether the company will in fact be heading towards a crisis, will not be able to pay more and more creditors. In that case, section 66 is a see-through provision, wherein the directors in case of a company and the partners in case of an LLP are made personally liable for such debts where the company has been fraudulently trading or wrongfully trading. They will be made personally liable for the debts. So, this section has been slightly amended by this Insolvency Ordinance. By this ordinance, the ordinance says that if there is a wrongful trading, I am not talking about fraudulent trading, this aspect has not been touched by the ordinance. If there is a wrongful trading, like if you know that the company is in a bad shape, despite that you are in financial trouble, you feel that you might go for insolvency, but despite that you want to continue business, say for instance you pay your employees before you pay the bank and continue business, then in such a case, the government has protected you from the actions of personal liability for this default period, that is during this protection period of 6 months. If you take such actions which you continue the business despite being in turbulent times, then you will as directors and partners not be made personally liable. Let's take a look at the Supreme Court's, the Apex Court's order by which limitation period has been extended. So the Supreme Court realized that this was an unprecedented crisis, and to prevent the litigation and lawyer from any trouble, they have extended the period of limitation. Let me read out the exact nature of extension that has been granted by the Supreme Court, and this is applicable even to tribunals. So any action which is taken by any litigant in the NCLT, he will be able to take benefit of this order. This is Writ Petition 3 of 2020, Suo Motu Writ Petition Civil 3 of 2020, for anybody who wants to read the full order. I am reading just the relevant excerpt of this order. To obviate such difficulties and to ensure that lawyers and litigation do not have to come physically to file such proceedings in the respective courts, tribunals across the country, including this court, it is hereby ordered that a period of limitation in all such proceedings, irrespective of the limitation prescribed under the general law or special law, whether condonable or not, shall be extended with effect from 15th March 2020 till further orders to be passed by this court in the present proceedings. So friends, this is a very welcome decision, and it will make any person who is facing running out of the limitation period in this corona crisis time, you can take advantage of this decision wherein the Supreme Court has extended the period of limitation. As regards limitation, you should also see certain amendments that have been brought in the regulations of IBBI. For instance, in the CIRP regulations, timelines, the limitation period was extended. So these amendments also you should take a look at. That's it for today. Thank you so much for watching.